legal advisor to Freedom of Religion South Africa, commonly known as 4SA. Today I want to talk to you about the Hate Speech Bill, a proposed law that the South African Parliament is considering making. Specifically, I want to highlight how the version of the bill currently in front of Parliament is more draconian than apartheid-era legislation, which saw the state censor and jail people. Now, the apartheid government was renowned for its strong censorship, where certain music, images, books, etc. were all banned by the state, and those found in possession of them were fined or imprisoned. It was only after South Africa became a democracy that the right to freedom of expression was entrenched. This right did not exist in South Africa before our interim constitution of 1993. This right to be able to say things, even things that the state might find deeply offensive, and not have to go to jail for it, is crucial and has been hard fought for. Now, many people, including 4SA and the wide cross-section of religious communities whose views we represent, are deeply concerned that the hate speech bill, which is currently in front of Parliament, proposes criminalising speech it deems to be hate speech and sending people to jail for up to 8 years for it. You can literally be sent to jail for saying something, sharing something, for example, on social media. All of this is especially concerning since the bill also criminalises the distribution and display of what it deems to be hate speech, while only providing narrow grounds for exemption that do not seem to provide strong enough protection for artists, academics, journalists, or religious people. Simply put, the bill does not properly protect South Africa's right to publicly express unpopular opinions, thoughts, and even offensive yet constitutionally protected beliefs due to its wide definition of hate speech on the one hand and its narrow grounds for exemption on the other. The reason given to justify the need for this law is that it's needed to curb racist speech, which undermines our democracy. This is simply not true. The cases of Vicky Momberg and Penny Sparrow, for example, have shown that we already have the common law crime of criminalising in South Africa that can be effectively used to send people to jail if they willfully injure someone's dignity. We also have various civil sanctions for hate speech under, for example, the Promotion of Equality and Prevention of Unfair Discrimination Act, commonly known either as WEPUDA or the Equality Act, which also has already been effectively used to combat instances of hate speech, such as in, for example, the cases of John Kwelani, Bongani Masuku, and Volapi Khumalo. Now, the excuse of needing a new law to send racists to jail is therefore not strong enough to justify criminalising speech in a way that will likely stifle public debate, because people will be too afraid to publicly express unpopular opinions for fear of going to jail for hate speech. Now, the bill is currently being considered by Parliament's second house, the National Council of Provinces. 4SA will continue to monitor the process and alert you as soon as public comments are open. So please do keep an eye out on our Facebook page at Freedom of Religion SA and our website at www.forsa.org.za.
This is Michael Swain of 4SA. Remember to like and share this video and then click on the subscribe button to make sure that you never miss our video updates on vital religious freedom issues.